Hi, I'm Janice Switlo, and today I'm continuing with part 17 of my book, Cede 2.0. Things are permanent fast with the FNLMA. It is all over within 10 days of the vote. Quote 14 sub 1, the verifier shall, after receiving the documents referred to in subsection 13 sub 1, certify the validity of the land code unless the verifier, after giving the First Nation and the minister a reasonable opportunity to make submissions on the matter, but within 10 days after the conclusion of the vote, is of the opinion that A, the community approval process confirmed under paragraph 8 sub 1 sub A was not followed, or the community approval was otherwise irregular, and B, the land code might not have been approved but for that irregularity. Transmittal. Sub 2. The verifier shall, without delay, send a copy of the certified land code to the First Nation and the minister. Presumption. Sub 3. A certified land code is deemed to have been validly approved by the First Nation. It is important to understand how this Section 14 FNLMA standard differs so significantly from surrender procedures under the Indian Act, which requires strict adherence to the Indian Act and regulations. Quote, First Nation means a band named in the schedule. End of quote. The band acts through the chief and council, meaning there is zero provision for any, quote, First Nation member, end of quote, to make submission regarding the voting process. Otherwise, that defined term, quote, First Nation member, end of quote, would have been included in section 14 sub 1. Bracket, quote, First Nation member, end of quote, means a person whose name appears on the band list of a First Nation or who is entitled to have their name appear on that list, close bracket. Note, regarding First Nation Land Management Act, that we are never talking about Indigenous nations and their nationals. We are always only talking about Indians and Indian bands as defined by the Indian Act. This is merely Indian Act 2.0, but there is no consolidation like what has happened a number of times through the history of federal Indian legislation. You still have to look at both the Indian Act and the FNLMA. Quote 2 sub 2, unless the context otherwise requires words and expressions used in this act, that's the FNLMA, have the same meaning as in the Indian Act. The definitions are clear. So equally clear, this is not some regaining of jurisdiction. It is the granting through federal legislation of administrative functions to a federally incorporated new mere creature of the law. But this is how the FNLMRC spins it on its website. Quote, congratulations to Broken Head Ojibwe Nation, who ratified their community's land code under the Framework Agreement on First Nation Land Management. On Saturday, December 13th, 2014, Broken Head Ojibwe Nation community members voted in favor of regaining jurisdiction over their lands and resources, once again placing control of the future of their lands in their hands. Congratulations, Broken Head First Nation. And that was published on December 15, 2014 on their website. The FNLMA regime is not the casting off of the Indian Act that has interfered with the exercise of continuing jurisdiction. Rather, it is digging in deeper because the FNLMA is a spawn of the Indian Act. Jurisdiction still exists even where administration is inadequate or terms of the Indian Act overstep the limited authorities to administer as per the treaties, so long as the offending provisions are never agreed to or representations are not made as to never having had the jurisdiction in the first place, like is done through pleading the Section 35 Constitution Act 1982 doctrine. As a new mere creature of the law, it is being granted permission to administer Crown property, today as, quote, surrendered reserves, end of quote, tomorrow the plan goes, as fee simple estates under the First Nation Property Act. Did the people really know what they were voting on? Regardless of numbers outcome, can it really be demonstrated that they were fully informed and thus freely provided consent to this? Even holding a land code vote is fraught with danger. There is no need to even adhere to the, quote, community approval process, end of quote, part of the FNLMA, if in the opinion of one person, the verifier, as per section 14 above, quote, well, that doesn't matter because they would have approved it anyhow, end of quote. This is a finding of fact, and generally speaking, findings of fact cannot be appealed. There is no appeal under the FNLMA in any event. Section 36 sub 1, every determination under this act or the framework agreement by a verifier or arbitrator is final, and no order shall be made, process entered, or proceedings taken in any court, whether by way of injunction, certiorari, prohibition, mandamus, quo warranto, or otherwise, to question, review, or prohibit such a determination. Actions final, sub 2. No order shall be made, process entered, or proceedings taken in any court, whether by way of injunction, etc., or otherwise, to question, review, or prohibit any other action under this act or the framework agreement by a verifier or arbitrator, or any action under the framework agreement by a neutral evaluator, end of quote. There is only the ability to pursue judicial review pursuant to section 36 sub 3 of the FNLMA, which in turn references the Federal Court Act. Sub 4, the federal court may grant relief under subsection 3 if it is satisfied that the federal board, commission, or other tribunal, A, acted without jurisdiction, acted beyond its jurisdiction, or refused to exercise its jurisdiction, B, failed to observe a principle of natural justice, procedural fairness, or other procedure that it was required by law to observe. And that's the Federal Court Act of 1985. And the Minister of Aboriginal Affairs appoints the verifier, who makes that finding a fact. Quote, Mr. Bear, that's Chief Austin Bear, Chair of the Lands Advisory Board's Finance Committee and Chair of the Lands Advisory Board's Reference Center. On the independence of the vote, there are also provisions. There is an independent verifier, that the land code is in accordance with the framework agreement, and that the procedures for vote are followed as prescribed. There is also a ratification officer applied by the First Nations so that the vote is in accordance with the provisions. It is not the First Nation that appoints the independent verifier. We at the Lands Advisory Board Resource Center make recommendations on trained and accomplished verifiers, but it is actually the Minister of Aboriginal Affairs that makes the appointment. Proceedings of the Standing Senate Committee on National Finance, Issue 22, Evidence, June 13, 2012, afternoon meeting. Further, the verifier is immune. Section 35, no criminal or civil proceedings lie against an arbitrator, mediator, neutral evaluator, or verifier appointed under the framework agreement or this act, or any member of a board established by section 38 of the framework agreement who is in good faith exercising a power or performing a duty or function in accordance with the framework agreement or this act for anything done or omitted to be done during the course of the exercise or purported exercise of any power or the performance or purported performance of any duty or function of that person in accordance with the framework agreement or this act. Members of the LAB, that's the Lands Advisory Board, thus also have immunity. Section 38 of the Framework Agreement establishes the LAB. A Creole proverb said to originate from Mauritius reminds, the advisor is not the payer. The one who gives advice has nothing to lose. That community approval process, there is nothing compelling the people to be given copies of the actual land code and individual agreement they are voting on. They only must be provided with, quote, content, end of quote, which can be summaries of those documents that can actually be nothing more than propaganda. The standard is to only take reasonable measures to inform them. A mere table of contents could even satisfy. Quote, submission to members. Section 10, sub 1. If the verifier determines that a proposed land code and a proposed community approval process of a First Nation are in accordance with the framework agreement and this act, the Council of the First Nation may submit the proposed land code and the individual agreement to the First Nation members for their approval. Sub 3, the council shall, before proceeding to obtain community approval, take reasonable measures, such as those described in the framework agreement, to locate voters and inform them of their right to vote, the means of exercising that right, and the content of the framework agreement, this act, the proposed land code, and the individual agreement. This is why so many people who contact me for input on the FNLMA regime, when a vote on a land code is pending, cannot provide a copy of the actual land code and the individual agreement they are to vote on. And there is nothing they can do to force provision of a copy. So there is also, in such circumstances, no way for them to obtain independent legal advice, it being impossible to provide opinion on someone else's interpretation. Lawyers need to see actual legal documents. Once land codes are in effect, they are published on the LAB website, and there are templates and model land codes also published there. But that does not assist the people faced with the vote on the land code. They need to know what their proposed land code is. The FNLMA could have easily and clearly required the provision of the proposed land code and individual agreement to the voters, but instead allows for easy refusal to provide same. The conclusion is that was a deliberate legal drafting choice.